All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Hernandez against Barrera, our cause number 1CA CV 16-0529. Counsel, I'm sure you know the practices in Division 1, and we have reviewed the briefs and are fully prepared to discuss the issues. We will be audio and video recorded today, and those recordings will be made available online to the public within a few days of the argument. Each side will have 20 minutes for oral argument, and the appellant is free to divide that time as you see fit, subject to watching your own clock. And if you're ready, we'll begin.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the appellant, Hernandez, who was the petitioner in lower court proceedings. And I'd like to reserve 5 minutes of my time for rebuttal. A lot of issues to cover today, but I want to get to the main issue before we're out of time, and that's the house, the former marital residence. Judge Garcia, the lower court judge, had ruled that based on the clear language of the decree, that mother was entitled to the house proceeds.
Stipulated decree, yes?
There's a consent decree, yes, sir.
Okay.
But the condition under the clear language of that decree, though, was that she had to obtain refinancing within 60 days. She didn't do that, so that provision is no longer.
What, in your view, what would have happened if she obtained refinancing within 30 days and then 10 days later sold the property?
That was her. Well, she had to pay the community debts.
Right. And if she had done that,
And anything left over belongs to her.
Exactly. That's what. The
So
consent
why is that different than if I can't get I can't refinance, I just need to skip that step, I'm just going to sell the house? Why does that? How does that affect your client's position in any way?
She didn't have the option to sell the house. That wasn't the term.
But she did. She certainly wasn't precluded from it if they've stipulated that this is going to be your house. You have to refinance, you can pay off the debts, and from there, whatever equity is in there belongs to you. Isn't the point of refinancing so you can pay off the debts?
But also to keep the house in the family. There was some testimony from my client that their intent was to keep the house in the family.
but that wasn't in the decree. I mean, there was no restraint on alienation in the decree.
No, but
I mean, what if the decree called for refinancing, payment of community debts, painting the garage door, and then all remaining equity goes to wife, and she refinances, pays the debts, doesn't paint the garage door? Is there a problem with enforcement of that decree? I mean, how is your client prejudiced by that?
because it wasn't sold in separate property, that's fine.
Not after the decree, it wasn't.
Well, remember, that's not an adjudication. That's simply an agreement for purposes of the consent decree.
No, when the consent decree is signed by the judge, it's an adjudication. It's an adjudication with consent, but is it? I mean, wouldn't you agree that once the judge signs the consent decree, that is an order of the court, enforceable?
Of their agreement, yes, sir. There hasn't been an adjudication as to the characterization of that property because my client agreed to treat it as community.
Well, collateral estoppel may not apply because there wasn't active litigation, but no matter how the court got to its conclusions, when the court enters an order, isn't one order as good as another?
Correct, but we have to read the language in the order.
And the language of the order contained nothing about restraints on alienation, and no economic terms by which your client would be prejudiced in his receipt of the benefits of his agreement or the equitable division in the decree, as long as the community debts were paid. Right? I mean, his only stake in this was having the community debts paid promptly. After that, he loses the house and the remaining equity. That was the deal, and that was the order. So I'm coming back to Judge Catani's question and not understanding how your client even really has standing to contest that.
I don't know if we need to show any prejudice or anything like that. What we need to show is that the decree was followed. And the decree did not give any interest in that property unless she refinanced it. So that's the language I'm relying on. You have to do a strict interpretation of the decree, you can't look to parole evidence.
So how did you get to the, and then my client is entitled to half of the profit? What's the excess profits after all the debts are paid? Where does that come from?
That was the position that he took in one of his petitions. Then he changed that to the Rule 69 agreement that he wanted to enforce.
What does refinance mean?
Take the mortgage out of his name and put it in her name.
Why doesn't refinance also include a sale? If she takes the mortgage away entirely and he is no longer liable for it, what does he care if she's making debt service payments?
Well,
Isn't a sale a form of refinancing, in other words?
Well, certainly, but refinancing and selling property are two different things.
Well, but you,
Because she can-
I think that sentence contains two contradictory statements. You said first that refinancing is a form, or selling is a reform of refinancing, and then that they're different things. If selling is a form of refinancing because it eliminates the underlying obligation, which is what that's his benefit, right? Is he gets off the loan, he has no more obligation. So she sells it to eliminate that obligation, as opposed to takes on an obligation of her own. What's the material difference there?
Because by taking on debt herself, she has the use of all the equity. But
By selling it, she has the use of all the equity too, just faster.
well, that was his option too then. If
No.
they had agreed just to sell the property, hypothetically speaking, he would want some of that.
But the purpose of that clause was saying, for husband, I'm no longer on this debt. That house, I am no longer in the debt on this house, and these other debts have been paid off. And so if she can't refinance it, why, and says, I want to sell it, why doesn't that accomplish the same purpose as the decree?
It changes the language of the decree, it's modifying it.
If she had refinanced,
Same as a sale.
if she had refinanced, going back to Judge Catani's original question, if she had refinanced it on day one and sold it on day two, does that violate the decree?
Well, no, because the decree wouldn't pertain once she obtains.
So essentially, you're saying that your client has an interest, an enforceable interest in ensuring that his former spouse is in debt. That's the only difference between those two scenarios. One, she's in debt, and one, she's not in debt. But he's not in debt either way. So why does he care?
He's in debt now. That was the agreement that she would take over the debt.
No. The agreement was that the mortgage would no longer encumber his finances, right? So if she refinances on day one, sells on day two, we have no problem, right?
That's right, because she had to.
So if she doesn't refinance on day one and sells on day two, what's the difference?
Because she didn't have the authority to do that, and because it's in my client's name with the disclaimer deed. He was giving it up for-
Let's put aside the disclaimer deed for a second. Okay, I know you like the disclaimer deed, but let's put that aside. What's the difference in that scenario? I mean, your client, the goal of that clause of the decree has been met. Your client is now debt-free on the basis of the house, and the community debts have been paid off, the stated community debts have been paid off, but he's saying, no, I get half of the equity because you didn't refinance, because you didn't go into debt. That's what you're saying.
And where is the legal interest that he has in ensuring that she's in debt?
To get the debt off of his books, so to speak.
But the debt, if she sells without refinancing and pays off the entire mortgage and the community debts, the debt is still off his books. So I guess I'm seriously having trouble seeing how he has standing to assert that she's violated the order if he gets every benefit that the order conferred upon him.
Except that wasn't the terms of their agreement, that she had to refinance was their agreement and to allow her to sell it.
What if she refinanced twice? Would that be okay?
Refinance.
She refinances on day one, and then a week later, interest rates tumble, so she refinances again. Can she do that?
Certainly. So long as she's met that first condition, she refinance. So I'm interpreting the decree strictly, and that's.
Quite strictly.
But the
Yeah,
decree doesn't address the scenario where wife is unable to refinance. So if you But isn't the more logical interpretation then that the clear intent of the parties is the value of the house is to be used to pay everyone's debt, and then whatever is left over goes to mother? If there'd been something in there that said, we want this house to remain in the family so the kids can live in this residence for the next 30 years, there may be something to that, but there's nothing in there about that mother is forever precluded from selling this property. And without that, it seems like the much more logical interpretation is simply make sure father's name is off the debt, the community debts are paid, and anything left over goes to mother.
I guess I'm not seeing it your way because of the title of the property. She could not sell that property. There was no way she could sell it.
Well, how could she refinance it if she couldn't sell it?
Because the mortgage, she could take.
Who's going to lend her money on a house she doesn't have title to? I think the theory was the decree gave her title so that she could refinance. Right? If it's his sole and separate property, how's she going to take out a mortgage on it?
That's the problem with this decree. It was so poorly written. It's like the cart before the horse. She couldn't refinance if she didn't have the title.
So then the decree made her compliance impossible. If you want to read it that way.
Could have quick claim title over to it. I'm sure that could have been easily handled.
But it wasn't required. So as written, if you want to construe it as strictly as you seem to say we should, the decree is absolutely impossible for wife to perform, and therefore illusory, because she's never getting this house.
Opposing counsel and I were talking about how crazy this deal was to think that mother would even qualify based on her income in the first place. But those are the terms she agreed to.
But in income aside, it's a pretty fundamental point that no one's going to lend you money on a house that you don't own. You have to have title by virtue of the consent agreement.
Sure, and like I said, you could have quick claimed it to her. Which you
Okay, but the premise is she has title to it by virtue of the consent agreement that the court has signed off on.
What if?
What I'm trying to argue is that she never acquired title until she tried to refinance.
What if she had gone to a bank and they said, wow, this is the deal of the century. We can't wait to refinance this property. The only problem is you need a quitclaim deed, and he had refused.
Oh, okay.
Could he have refused?
No, because he'd be interfering with her opportunity to perform the decree.
Exactly. So the underlying premise of the decree was not that it was his house that she was refinancing. It was her house that she was refinancing, and he might have to do something in the nature of further assurances to execute documents to make the decree work. But there's nothing in that decree that suggests for a moment any intent by the parties or the court to make it his house. Isn't that a fair statement?
The underlying premise is that it was his house, and that he agreed to treat it as community property for purposes of the consent decree. And when that consent decree provision was not...
And once that consent decree becomes a judgment, we're done, aren't we?
Not if it wasn't performed according to the language.
Because you're saying it never became community property until she could refinance. Problem is she couldn't refinance because it wasn't in her name. It was in both their names.
I don't know what they were thinking when they did this.
Yeah. And you know, there's a real problem for me in this, in that sense. If we agreed with you, wouldn't we have to send it back to the trial court and say, all bets are off as far as division of property? If it goes this way, you may have to look to see if there's equitable liens. You may have to revisit who gets the business, who gets the truck. Everything would be up for grabs.
Exactly.
That could be a real problem.
Well, no, because we still have a record as far as the evidence goes on the value of different properties. It's just the equitable lien would have to be done.
Think about it. If we wrote the opinion you want us to write and published it, is that an opinion you really want to have on the books?
We might have published it.
But it could still be cited.
But I didn't mean from the standpoint of judicial economy. I meant from the standpoint of substantive law, because the effect of that opinion on future cases would be to say that a technical inability to perform an irrelevant part of a decree is going to actually deprive the other party of their benefit under that decree. So if we had a slightly different scenario and wife says, I can't refinance, but I have a great offer to sell it so I can get you off the mortgage, we would then have a Court of Appeals opinion that says, no, we read these things strictly, you can't do that. And the husband who wants that debt off his books can no longer get the benefit of that agreement because the parties can't do something eminently sensible and substantially economically identical to what the decree requires. Is that really the law that you want to have advanced?
That's the way the law is now when it comes to omitted property. If you didn't
But this isn't
specify-
omitted. This is far from omitted. This is expressly.
But in the general scenario of being specific on what you say goes to what party, you guys have always told us, you've got to be specific on property you're going to deem omitted.
Specific drafting is different from strict reading of decrees to the point of economic irrationality, though. I mean, if you can do something that is economically identical and confer the benefits of the judgment on both sides, do we really want to interfere with people's ability to do that? That would be, it seems to me, the Court of Appeals micromanaging people's lives because of the virtues of strict construction, but not allowing them to realize the economic benefits of their agreement. Is there any public policy that supports that?
Public policy is that the people should be held to them for their bargain, that's for sure.
Well, that's kind of what I'm talking
That's why
about.
my father gave up his sole and separate interest to deem it community property for the purpose of her taking the debt over.
So that he would not be indebted.
Which is exactly the result that the trial court ordered, isn't it?
Can I try the Rule 69 argument?
Sure.
Might as well.
The Rule 69 agreement, which was initiated by the wife, signed by the wife, and delivered to the husband, should have been enforced. It was fair and equitable, assuming that the wife had no interest in the property, that she would take $20,000.
That's a big assumption.
Well, based on what we've just been talking about, I suppose.
It might not be a safe assumption based on the.
But it is a Rule 69 agreement.
Well, it also says end payments, right? Isn't that the one that said end pay $20,000 end payments, whatever that's supposed to mean?
As a surplusage, I don't think it really had any effect on
You don't think
the
so?
terms.
But don't we have to construe it strictly? Don't we have to construe it strictly? I mean, I'm really not being difficult with you, but one of our canons of construction is that we construe agreements and statutes to avoid surplusage. I mean, that's bedrock.
Well, pay $20,000 and take over the payments, I think is what was intended, but I'm speculating.
Yeah.
Because we never really got into what, but remember Judge Garcia didn't find that in the
Yeah,
court. so-
she found it was unfair, and it was not fair and equitable. Or, although I think she did say if there was an agreement, right? She said if this was an agreement, it wasn't fair and equitable.
Right, she deemed it, and the assessors have a discussion to Rule 69. But when you look at the way the assets have been distributed, husband's business had no value. He's a laborer, and all he does is manage people. I don't know how you can place a value on something like that. In fact, the testimony was mother was just guessing as to what it was worth. So to give mother all of the equity in the house is not fair in terms of the distribution of the other assets.
How are we to conclude that husband's business had no value? Is there evidence? Did the court make a finding?
Yes, he testified to that.
He said it has no value.
The court didn't make any valuation.
But the husband agreed to that.
But then how do we review a valuation the court didn't make?
That's-
And your client's not,
No competent evidence to support the
but
court's
and you're
decision.
suggesting that it would not have been unfair if wife had simply refinanced. Your argument was just she had to refinance. So it seems hard to get. I tend to agree that it doesn't look like there's much value to the business, but that doesn't seem to, the argument seems to have just been, well, because she wasn't able to refinance the property, that somehow makes every other aspect of the agreement unfair.
Well, if she's not able to refinance, why does she get all the equity in the house? That doesn't seem fair to the husband.
Oh, but if she refinanced, she did get all the equity in the house.
True.
And if she sells it off, she should get, because his benefit is, I'm no longer indebted and these community debts are paid. So he gets the benefit of the bargain.
But because it didn't happen, though, the parties are right back to square one.
Okay. We could just beat this horse a little bit more.
Thank you very much.
you to read the consent decree as it's written without the notion that there's this hidden clause somewhere that this property would return to your husband as a sole and separate property if a refinance could not take place.
Well, let me ask you a slightly different question. Because I think from what you've witnessed, we're pretty familiar with what the decree says. But I think the concern here is what it doesn't say. So let's say that wife was able to refinance the house, but the appraisal came in low. So she refinanced the house, got husband off the mortgage, but wasn't able to satisfy all the community debts. How would you read the decree, and what would you expect the consequences to be then?
Well, I read the decree that she gets the remaining equity after the debts are paid off. And
But what if there's no equity? I mean, my hypothetical is not only is there no equity, but there still remains community debt, and as we know, creditors can enforce all that against husband.
right, both parties continue to owe the community debt 50-50.
You think that's what the decree contemplated?
I think the decree contemplated that the equity would be used first to pay off the community debt and taxes.
But as happens sometimes in recent years, there's not even enough to pay off the debts. I mean, there's equity enough to refinance, but not enough to do anything else. In that situation, then I think we would have satisfied Mr. Murray by saying, well, she refinanced, right? We can strictly construe that. But wouldn't he have a valid objection then that the purpose of the decree wasn't realized because the community debts weren't paid?
But I don't think that's a sensible objection because there's two ways to pay off the mortgage. One is to sell it and the other is to refinance it. He doesn't even get the relief offered by paying off the mortgage in the sale because he's objecting that he can't sell this property, or they both can't sell this property unless the debts are also paid off. And that doesn't make sense because then he's on the hook for his mortgage. Wife is in possession. She owns the equity as it starts to accrue in the home.
But that's
and they both owe the community debts.
That sounds like an argument you'd make at trial. That doesn't sound like an interpretation of the decree. It seems to me that the decree did contemplate that there would be certain benefits afforded to each party, and one of those was full payment of the community debts.
Yes, I agree, but I think it's clear to me that the decree contemplates that there's equity, community equity, to pay off the community debts in the property. It specifically says that the equity in the house will be used to pay off the community debts and taxes, and then any net will go to others.
Sure. All I'm getting at is an interpretive question. I'm suggesting the failure of another condition in the decree. Right now, we have the failure of the refinance condition. But what if we had a failure of it? And your position, I assume, is who cares? You got the benefit from having the debts paid off,
Maybe
right?
that's too practical, but I think that it's clear to me that it was intended that the house be sold and that his name be removed from the debt. The problem is, how would the house be sold? How would it be conveyed to mother to? And that would be, like you said, a mechanical provision. A quitclaim deed needs to be signed over at the time escrow closes. But that is one benefit he gets. Now, what if he doesn't get the whole benefit of the decree and the parties continue to owe this community debt? Would he actually go into court and state, I don't want the property to be sold. I want my wife, well, she's been ordered. And the decree says that property in possession, the person in possession owns the property.
But why couldn't he rationally go into court and say that? Maybe he could say, look, the market's going up. My best chance of getting these debts paid off is for wife to hold that property until she can comply with the terms we agreed to. So let's wait a couple of years, and then there will be enough equity to do this. Couldn't he rationally insist that she keep the property at that point?
Yes. I think, well.
I know it's a hypothetical. I get it.
Hypothetical. I do think that this decree is stating it is community property. This is a division of community property. There's nothing in the decree to say it's a conditional judgment, which means that she has to perform a certain condition, refinance, in order to gain that equity in the property. It doesn't say that, which is his argument. This is a conditional judgment, but it doesn't say that. So I mean, it's a tough scenario, you know, and this did happen in the recession, that people didn't know what the equity was in their property, and they found out, well, if we sell it, we can't pay off our debts. But I think they're gonna have to amend, if they can't refinance or sell, and they can't pay off the community debts, it seems to me that they will still have to amend their decree, come up with a different agreement, or she could still go in and get the house ordered sold, because basically there's just no equity to pay off these debts. That may have been
You're suggesting that at a minimum, the decree evidences that the house is community property, there are community debts. To the extent there's any equity in the house that can be used to pay all of the community debts, that's what happens with it. That's kind of the initial step. And then if there's anything left over, it goes to wife. But certainly if the initial step is it's community property and there are community debts. And if the community debts can't be satisfied, then there's still community debts. It doesn't extinguish, it doesn't change the nature of the debts from being community debts.
correct. I think that wife still has an argument that this property needs to be sold to satisfy the husband's mortgage on it so that she can continue to own it. Or perhaps it needs to be sold in a short sale if she cannot sell it and pay any of the debts. And that the problem with the debts is they continue to be community debts. And you're right, it leaves them exposed to lawsuits by their creditors on both sides, unless they do a bankruptcy or something else. But I think that seems to be what the decree is saying. It's basically saying that there is equity, it's community in nature, that she has the option of refinancing. If that doesn't exist, the decree is silent about the sale. It's silent about how she will receive her equity and
Well,
how the creditors will be paid.
And what she came in, if I understand the record, she came in and said, let me sell the house.
Yes,
That was her petition, which I think the court granted that, correct?
yes.
So the court's going to let her sell the house. Of course, she doesn't have title to the house.
She doesn't have title, and there is a how. How will
But,
she?
but I would assume, presumably at that point, since the judge has said, go ahead and sell it, if she gets an offer, she's going to turn to the husband and say, quit claiming your interest to her so the house can be sold.
Exactly, and at that point, they could end up in court, they could end up with someone asking the court to order the sale and order
And the court might have to deal with, at that point, what do I do if the house sells and so the mortgage is satisfied, mortgage is gone, there's no debt on the house, but there's not enough to pay off the other debts. I may have to look at that because it wasn't the court could say, I don't know what's going to happen, and so maybe we need to relook at the decree. As to that aspect of it, not the aspect of refinancing or selling, but the aspect of, well, if there's not enough money to pay off the debts, what do we do?
Right. That could happen. I mean, there are enforcement questions. They could ask the question of whether this was a sale for fair market value, whether it was a third-party transaction. How did they get there?
Court could appoint a commissioner to sell the property too.
That's true. They could get back into court, husband could say, no, I don't want it sold because all of the community debt had to be paid off. And wife had to receive community equity in order for the sale to take place. And he could look at it as an investment, but I don't understand why he would do that if the equity is clearly for her and then the community debts have to be paid off. The only reason he would have for doing that is he would say, well, I'd rather have my creditors file a judgment against this property, which is community property, rather than sell it and have them, come after something else I own.
I mean, technically, we're talking about hypotheticals. Wife could try to sell the property and sell it, get an order to prove selling it, pay off the debts, and have no equity,
That's true.
zero. And that's the risk she takes.
And that was her risk. If she did not come in, she made this agreement, and we do not know whether she had an appraisal or either one of them had an appraisal, but it's clear to me that the intention of the decree was to award the property to her, and it does clearly state that this is a division of community property. And there are other provisions in the decree which say this is community equity, and it's to be used to pay off the purchase of 2 beds by father. It seems to me, it also says that the property in each party's possession is awarded to them. That's a very general provision, whereas father has argued in this appeal that it says personal property. But if you look at the decree, it doesn't say personal property. I mean, I just think there is a missing provision. It's silent about what do we do if there's no provision for the sale. But I also
You're not
see-
suggesting the house goes pursuant to the property that the parties are in possession of, when it's specifically referenced, and it's real property that's referenced as now essentially a community asset?
It says, usually, my experience is if they want to award personal property, they write personal property as opposed to real property. In this particular decree, it states each party is awarded the property in his or her possession.
But there's a separate provision that specifically addresses the house.
Yes, there is, that's true. There's a separate provision on it. But it's kind of, there's a case that says you have to construe it in harmony with the other provisions in the decree. And those
But if there's
other
a specific provision, there's no reason to harmonize anything. Wouldn't that be the more specific provision that controls as to how the house is to be disposed of?
Right. Yes, like I said, there's silence about the sale, but it clearly states wife is awarded the equity in the residence after.
Isn't the real point of this is what the judge is trying to do in ordering the house sold, was trying to reach the benefit of what the parties were trying to do in that clause, which was get husband's name off the debt, pay off the community debts, and any equity, remaining equity, if any, will go to wife. And that's what the judge was essentially doing, saying, I don't care if you refinance it, I don't care if you sell it. That's the goal. The goal is everybody, the debts get paid off, husband gets, you know, if she had won the lottery and paid off the mortgage and paid off the community debts, it would have had the same effect.
That's
Right.
how I see it. I see it as the equities in this decree were presumed to be fair at the time it was signed, and it's clear that the parties intended in their agreement that wife would receive the equity in that residence. So why would the court later on adjust the equities and say, well, I think that, you know, there was no disclaimer deed at all introduced at trial. No one knew it was a sole and separate property of the husband. Why would the court later on decide that he should have this property? That, oh, it's a conditional judgment. She didn't refinance, so therefore it belongs to him. Doesn't make any sense. She's not awarded anything else in the decree. It seems inequitable. And of course, he says that this business is worthless. We've heard that argument. We've heard it at the hearing involving the supersedious bond. He has never proceeded to show proof that his business is worthless, that it's not worth anything more than his labor. You've got tax returns introduced at trial showing that he got gross revenues of $392,000 in 2013, 2014, $320,000 were deposited to his bank accounts. There's plenty of reason for him to go down, and he actually did this after the decree was ordered, and amend his corporate articles to show it belonged to him. There was never, I mean, the court gets to decide how credible is his testimony that the business is worthless.
Well, he can change the corporate documents because the court awarded him the business.
It says that he's awarded the business after wife refinances. If he's going to be a strict constructionist, he isn't awarded the business because she doesn't
Okay.
refinance. So, you know, and if you want me to go on with my arguments, I know that he made an argument about the alleged statement. The wife made a statement on a little piece of paper that if husband paid her $20,000 and some payments, that's all she wanted, and that was an alleged Rule 69 agreement. Those agreements were briefed in the trial court. The and payments was a problem. It was very vague. It's impossible to know how to enforce that. If that is an agreement, how to enforce it, because we don't know what and payments are. So how can it be a binding and enforceable agreement? Secondly, the court found that in light of the consent decree, which awarded wife equity, that $20,000 was not fair and equitable to her. And at the time, we presented evidence that she had perhaps equity of $68,000. And of course, this fluctuates with the market. But in light of that amount of equity, the court found it was inequitable. And I think husband has proved that he has not met his burden of proof that she abused her discretion in that statement. And also, he never accepted it. There were arguments made that he went over to her house and he offered her $20,000. But as a matter of fact, he didn't have the loan proceeds from his second deed of trust until that particular offer was made into her house on September 9th. Well, he obtained his second deed of trust against the property for $40,000 on September 14th. He went into court and he never said a word about it. He acted as though the equity is intact, untouched by me. And yet he had transferred the property to himself. He had taken out a second deed of trust. He had not disclosed it. Certainly, wife had every reason to bring an emergency TRO because he had affected her equity interest in the home. There is no proof that he was entitled to do that, that he didn't have to disclose the evidence. It was an attorney's fees award made because he did not provide any disclosure to the court. It was under Rule 65 of the Family Court Rules. So when he says the husband had every right to take out that money and that this court could not apply an equitable remedy such as constructive trust, I don't think the case law supports that, and I don't think husband's conduct does. He did not segregate those funds into a separate account in case wife was entitled to that money. He spent it on his personal debt. He's clearly acting in an expedient manner in order to get the money, pay off his debt before he ever went into trial and heard from a judge on that subject. So we are entitled to affirm the trial court's ruling. Husband does have to pay off that $40,000 because it was part of wife's equity in the home. So, I don't know if there's any other questions. No.
Thank you very much.
Thank you.
Thank you. I stand Murray again for the appellant. Just not to beat a dead horse, but the language in this decree does not give wife the house. I'm reading from page 6 of the decree. The above property is awarded to respondent wife as her sole and separate property upon refinancing the mortgage to the property in her sole name. I don't know what could be more clear that it wasn't the intent of the decree to give her this house unless she refinanced it. She didn't refinance it. No deal.
But you know, it's not like a normal case, not a normal case, but in a lot of cases where they say, okay, this is community property, we're going to award it to you as your sole and separate property. In essence, it was saying, this is community property. Once you refinance, yes, it'll be your stuff, but you still have to pay off the community debts, even though it's your sole and separate property. And so it's sort of a hybrid where the court's saying, you know, the goal in this paragraph is get husband off that mortgage, get the community debts paid, even though it's if she could have refinanced it and gotten a quitclaim deed from him, technically it's her sole and separate property. But the court's saying, yeah, but you're going to use it to pay off the community debts, because that was the goal of this thing.
Sure, that's what's his agreement.
Right.
He's not contesting that he should get the.
No, that's all right. Go ahead and finish your
I was
sentence.
just going to say, he's not contesting that provision about paying off community debts is out.
No, he's saying he wants half of the equity after it's her sole and separate property. She uses it to pay off the community debts, and then he gets 50% of what's left. That's sort of an interesting hybrid, isn't it? Yeah, it's a good deal.
All right. Thanks to both counsel for your arguments. The matter is now under advisement. We will issue a written decision in due course, and the court will stand in recess.